Hey guys, what's going on? Just excellent job on last week with our polarization and gerrymandering lectures and your responses to both myself and your peers. You know, obviously, this last week has been perfect kind of topic to talk about polarization. So I'm really glad, that we are able to kind of mix all this stuff in together. This is just kind of the most wild time to be teaching this kind of stuff. You know what I mean? And so hopefully that makes it more interesting, if not a little depressing. But we are getting it done. We are getting it done. And for as long as we can, we're going to get it done, right? So, before I go into this lecture, though, I also just want to reiterate that I changed the initial video project, right? We're no longer doing a video. I just want you to write a 1 to 1.5 page, double spaced um, draft of your ideal constitution for the United States, right? If you were tasked with writing, rewriting the Constitution or amending the Constitution or whatever, that's what I want you to do for your project, right? There's no real format to this. You can kind of start with a long preamble, like the Constitution does. You can take inspiration from other constitutions. You can just have a list of specific rights and amendments that you want to do. I would prefer just a little kind of little not just a list but a little bit of writing, just kind of like emulating what the initial kind of sentences of the United States Constitution does, or and most constitutions do. But pretty much it's free reign, as I kind of like to do it in this class because I feel like you guys have terrific ideas and I don't want to constrain you. So, like I said, 1 to 1.5 pages, your version of the United States Constitution if you had to write it or rewrite it. Sounds good? Sounds good. Any questions? Just let me know. Figured it'd be a lot easier than doing a 8 minute, 9 minute video. Um, just the amount of research that you have to do and the amount of time that we have for your own topic would be a little difficult with a short period of time that we have. But anyway, that's that. I'm gonna move on to the judiciary. So this week we're gonna be talking about obviously Supreme Court, and in my next lecture we're gonna be talking about civil rights. All this is super intertwined together. We're finally going to talk in depth about Obergefell versus Hodges, the Supreme Court gay marriage case. We're going to be talking about Malcolm X. We're going to talk about the civil rights movement of the 60s. We're going to get into all that. But to start, it's probably best to kind of just establish what the Supreme Court actually does and what the federal courts do, right? So, first of all, Supreme Court, it's established in Article 3 of the Constitution. Um, and essentially, pretty much, there's two main roles that the Supreme Court does, right? And there's the original jurisdiction, right? Which most countries, their Supreme Courts don't have this. And then there's appellate jurisdiction, which is obviously what we usually see the Supreme Court handling, right? Cases start at like a state court, and then move up to a lower federal court, and then get all the way up to the Supreme Court, right? So also, it's important to note that in this article, no term limits, right? I'm not exactly sure what the founders were thinking when they did not put term limits for anything, especially the judiciary, when there is also no limit to how many justices there can be. It seems like a pretty big oversight, but I think this is one of those things where it's like, we're not going to agree on this. We're going to kick it down the road, right? So, nowadays we've settled on nine, but there's no actual limit on that, and we'll talk about that later. But anyway, important part for this is original jurisdiction, right? This deals with cases affecting ambassadors, upper public ministers or consuls, and those in which the states will be a party, states versus state cases, or foreign, countries, right? That's where the Supreme Court has original jurisdiction. The cases go straight to the Supreme Court. They don't start from the below, right? And then, of course, appellate jurisdiction starts from another lower court and then moves its way up to the Supreme Court. Um, Here's an important thing to know that most people don't. Congress is essentially in charge of changing the jurisdiction of the Supreme Court when it comes to appellate jurisdiction, right, which is the vast majority of Supreme Court cases. So, in other words, if Congress decides they don't want the Supreme Court to hear a case on, let's say we're in the 60s, on busing, and if this passes, then the Supreme Court legally cannot hear that case. And then, of course, Congress also has complete control over the federal courts as well. So it can essentially keep a case from ever reaching federal jurisdiction at all. So this class is a kind of, I'm just trying to give you guys some of the stuff that I feel like American politics classes often kind of just skip over it entirely, but it is important. Like when the founders wrote the Constitution, they wanted Congress to have a lot of the power, right? And then initially the Supreme Court was just kind of like a weak third branch, which obviously has changed over and over the years, which I'm going to get into as well. So, just for examples, right? Original jurisdiction: New York versus New Jersey on who controls Ellis Island. That's a state versus state issue. So its original jurisdiction goes straight to the Supreme Court. You don't deal with anyone else, right? And then, of course, appellate jurisdiction, as we know, Brown versus Board, Scott versus Sanford. All these cases, they go to the Supreme Court after going through the lower courts. Pretty simple stuff. And I just asked the question, is it fair for Congress to determine the jurisdiction of the Supreme Court? It seems that, like, again, for me, it seems like a bit of a cop-out, but I'm kind of interested in what you guys have to say, especially since the Supreme Court is, unelected officials versus Congress, which is obviously representatives of us, or supposed to be representative of us. I'm just wondering what you guys' thoughts on that, because it does seem a bit odd. Because if Congress can determine what the jurisdiction of the court is, then how is that really a great balance of power? It happens rarely. It doesn't happen very often, and the term is jurisdictional stripping, right? And most of the time, it's Congress kind of keeping the federal courts from being overburdened by stuff that's kind of not really relevant. But sometimes it's not. For example, Guantanamo Bay. I think it was 2006. Congress pretty much said that these guys can't, people in Guantanamo Bay can't have a trial. They go straight to a military tribunal, and they try to keep the federal courts from hearing this. And the Supreme Court eventually went to the Supreme Court, and the Supreme Court said because what did they say exactly? That pretty much everyone has a right to a fair trial if they're in the United States, and so they deemed the. It's very confusing. They said Congress can't strip the power from the federal courts because it's not within the power of Congress to do so. So it's rare. It does happen once in a while. Most of the time, it fails, just like that Guantanamo Bay case. And usually, the most prominent ones are, like I said, stuff like busing, segregation, McCarthy hearings, Red Scare, like we talk about, abortion, school, prayer, etc. These are all things that people have tried to keep the Supreme Court from hearing. By people, I mean people in Congress. I think most people are pretty set in the fact that the Supreme Court should hear these kind of cases, so it rarely ever kind of gets any momentum. But it's important to know that technically Congress does have the power to strip jurisdiction from the courts. So the important thing to know about the Supreme Court is judicial review. You hear this all the time. What exactly is judicial review? And so, like I said before, in the early times of the founding, right, Supreme Court, it's seen as a weak third branch of government, limited enforcement powers, which is something also that one could argue the Supreme Court doesn't really have much actual enforcement. Sorry about that, it's my phone. And then, that article that we just looked at, Article 3, it doesn't really say anything about the Supreme Court other than having its original jurisdiction and having the highest appeal court. I mean, that's not a lot of specificity, right? So this is not really an issue until Thomas Jefferson becomes president and the issue of Marbury versus Madison. Now, this is the Supreme Court case that pretty much establishes judicial review and kind of gives the Supreme Court its power. So just a quick background. I don't want to spend too much time on this, but this is kind of important to know how the Supreme Court works, right? So Thomas Jefferson becomes president. He beats John Adams in the presidential election, and then in retaliation, Adams pretty much says, you know what, screw this. I'm going to create all these new lower court judges. So Thomas Jefferson is essentially kind of not in a great place when he gets the office, right? And I'm going to make my buddy Chief of the Supreme Court. Chief Justice of the Supreme Court. This is obviously bad for Jefferson, and one of the commissions doesn't get delivered on time to this guy named William Marbury. And when Jefferson takes power, he's like, I'm not going to let this guy have this, this federal court position. He's against me. So he says, no, I'm not giving it to you. So Marbury goes straight to the Supreme Court, and he says, look, this is a federal issue. They're supposed to give me this mandate, right? And the Supreme Court in the Constitution says that you have the power to actually issue this for sure. This is under your authority. You can fix this problem. And this is when it gets a little dicey. So Jefferson, he's not supposed to withhold this mandate, right? Adams did it technically legally. He has to give it to him, right? But also, he doesn't want to give the Supreme Court too much power because, like he said before, the Adams' best friend pretty much just became Chief Justice. And so, if you give the Supreme Court too much power, you hamstring yourself. If you give him the mandate to become a lower federal court justice, then you also are kind of shooting yourself in the foot. He's in a pretty bit of a bind, right? And so there's also the issue that the Supreme Court doesn't really have much actual enforcement ability even today. So even if the court said, hey, um, Jefferson, you have to give this mandate to this person to become a federal court. Jefferson, we know a little bit about Jefferson, right? He probably just wouldn't do it. He probably just wouldn't do it. How is the court actually going to do it? The court does not have control of the military. The court has a few, judicial marshals and stuff like that. But you're going to go up to the president and say, "Hey, you have to send this." So there has to be some sort of solution here, right? So here's the solution. Chief Justice John Marshall, Adams' friend, right, agrees that Jefferson has to give this document so he can become a federal court. However, this is the big one. He says the Supreme Court does not have jurisdiction on the matter. He says that this is the beginning of the long history of the Supreme Court kicking the can down the road, essentially. So he says that because it wasn't, it doesn't have to do with ambassadors, it doesn't have to do with consuls, it doesn't have to do with the states, it doesn't have to do with a foreign power. This is not original jurisdiction. You have to go all the way back down to the state courts and then to the federal courts and then finally bring it back to us. And then we can deal with it, right? Even though in that, like we said before up here, or is it the Supreme Court should have the power to appoint this person to a federal court position. So it's kind of a cop out. It's a bit of a cop out. No, I shouldn't even say it's a bit of a cop out. It's a total cop out. However, um, it kind of works out at the end for the Supreme Court, and I believe for the most part you could say this is intentional, right? So John Marshall, who is the Chief Justice at this point, strikes down a law as unconstitutional for the first time ever. So this is kind of establishing this judicial review, saying, hey, this is unconstitutional, what is going on, right? And at the same time, he seems like he's limiting the court's power because he doesn't give Marbury his actual document, right? And so it's kind of like it's like I said before, it's threading this needle. He sees the occasion to uphold the institution of judicial review, right? It shouldn't be even uphold. It's the first time it's ever been used, right? And he did so in the course of reaching a judgment that his political opponents could neither defy nor protest. And if you look at the history of Supreme Court, it's always just trying to kind of not piss people off, you know what I mean, in terms of the politicians that are in power, and at the same time kind of establish some power of their own. It's a very long history of really kicking the can down the road and not getting involved in a lot of stuff. So at the end of the day, justice wasn't really served because the guy that was supposed to get his commission, he never gets it, right? Because if Adams appointed all these people to the federal courts, and you have to go to the federal courts or even the state courts before you get to the Supreme Court, they're never even going to let you get the chance. So justice isn't served in this particular occasion. However, it does strengthen the Supreme Court's ability to, call essentially the first time ever the Supreme Court says something is unconstitutional. It kind of cements it as its ability to, right? And yeah, it's that's kind of how the Supreme Court got its real start. Let me see. I don't want to make this one go on too long. How long we got here? 13 minutes. All right. So I will finish this slide. These next couple slides. Really quick. Going back to, can the Supreme Court actually enforce anything? Not really. Not really. Right. Again, like the Supreme Court doesn't actually really have much power to do. Again, no military power, no nothing. It's pretty much just 9 justices and a handful of judicial marshals that can kind of. They're supposed to kind of more supplements, you know what I mean, the enforcement from the other agencies, the other branches of government, the Congress and the executive branch, right? So Andrew Jackson, worst president ever. Hopefully you all know that. If you don't know that, go look it up. Andrew Jackson is one of those guys that said, I'm not going to listen to the Supreme Court. Really quick, just really, really quick background. There's this guy named Worcester, it's a minister. He teaches Indigenous Americans in Georgia about God, blah, 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 blah. He's trying to do all this kind of stuff. Also trying to be a good guy, using how to, use American law, I should say United States law to kind of keep themselves from losing any more land, right? Georgia passes this law restricting white people on native territory, and he is arrested, right? And then Worcester is pretty much making the right argument that since native territory has always been considered sovereign, right? This is not something that a state can do, and that he can go straight to the Supreme Court, and the Supreme Court will realize clearly, because this is a sovereign nation, that they can't arrest him. This is actually one of the few times that the court, I shouldn't say a few times, but especially early court, a lot of the decisions were pretty bad. But court sides with Worcester, rules the law unconstitutional, and they say you got to let this guy go. Long story short, he never gets freed. He serves how many years in jail? 4 years in prison, and then Jackson continues to pretty much ignore the law and evict the Cherokee people off their land in the Trail of Tears, which, as we know, pretty much is one of the worst genocides of Native people in the American history, and just incredibly brutal. If you don't know about that, I highly recommend looking into it. So, yes, the Supreme Court technically relies on the executive and the legislative branch to actually enforce the laws that it upholds, right? Again, there's not a lot of enforcement power. And you think about it, could this happen now, right? Nixon thought about handing over his incriminating tapes during Watergate. What would the Supreme Court have done? Well, the Supreme Court probably wouldn't have done anything, but I think there was enough public backlash against Nixon that someone would have taken care of it, right? Not the Supreme Court itself, but maybe I don't even know what the case would be, but the public pressure and political pressure would probably make Nixon, as he did, hand over the tapes regardless, right? Alabama, this was a big deal a couple of years ago, fighting to keep the Ten Commandments after the Supreme Court ruled it unconstitutional. Yet they kept it up for 2 years. No one really came and said, hey, you're breaking the law now, you know what I mean? Who's going to do it? Are you going to send the military in? Because the state police weren't going to do it, you know what I mean? Another issue. And obviously, this is under Obama's tenure, I believe, and Obama wasn't about to send the military into Alabama. That wouldn't be politically prudent at that point in time, right? And then obviously, how do you deal with stuff like prayer in schools? Like, who's going to come in and say that you can't do this, right? It's kind of a sticky situation. Again, because kind of my point is that at the end of this thing, the Supreme Court does seem to have a lot of power, but in the actual writing of the Constitution, which I think is something that we really should look at, the Congress can control the jurisdiction of these appellate cases, right? So it can determine whether the Supreme Court actually hear them. And then also, the Supreme Court doesn't actually have much enforcement power. So I'm just thinking, if we get to a situation, hypothetically, right, where, Supreme Court makes a decision that is unpopular, right? Is anyone going to actually listen to it? And I think we'll talk more about that when we get to the civil rights cases in my next lecture. Really quick, I also want to talk about, this is like one slide, federal judges, they pick by the president, right? They have to be confirmed for the Senate. And they also, like Supreme Court justices, have life tenure. This is why Trump was going on that spree, hiring all those Republican federal judges with maybe like a year ago, 2 years ago. Life tenure, is life tenure a good thing? Possibly not. If we look at term limits for Supreme Court justices, what about 18-year term limits, right? So a vacancy every 2 years, so every president has a chance to, get at least one. Pros, fair, reflects changing times of popular opinion, that might be good. Cons, if you're getting someone every 2 years, I'm sorry, that would make every president gets 2 picks for each term that they have. Constant reversal decisions, right? It could feel like an unstable kind of system because there's, a revolving door of justices, and that doesn't exactly sound too great either. They actually did some research on this, which is very interesting, pretty much showing that if you did have term limits, right, at the end of the day, you wouldn't really have much difference from the current system. So if you had a new justice every 2 years, the actual effects on whether people would want to overturn Roe v. Wade or actually keep it, it's actually pretty much the exact same as how it happened in real life. So maybe 18-year term limits isn't the best idea either. I'm curious if you guys have a solution to this. I'm not exactly sure what the solution is. Maybe I think the only thing I can think of is more justices, right? More justices in general. This way, life tenure isn't so much an issue because there's more than 9, and maybe eventually you will have someone that either retires or dies in office. You know what I mean? Really quick, then, that leads us to court packing. As you've heard, there has been some quiet talk about court packing. It's not going to happen. Talking about Joe Biden packing the courts because now it's a pretty strong conservative majority. I'm sorry, my phone's been going off this entire time. Let me fix it. People, please leave me alone. Leave me alone. I'm working. But yeah, court packing. It's not going to happen. There's no way that they're going to. I mean, I think it's a good idea actually, but I think it's pretty unpopular right now. People are happy with nine, and now that there's, like I said, a conservative majority on the court, it's going to make Biden's life a lot harder. But as we've seen Biden, he's as moderate gets, right, and he's not going to want to rock the boat. So I seriously doubt we'll see any form of court packing anytime soon. Although, seriously, I think nine is too few. Or unless you want to add the term limits, whatever you want to do, something needs to be fixed on that, right? But yeah, so like I said, nothing in the Constitution says how many justices there has to be. It's been varied a lot actually, but set at nine since 1869. And to do this, you need a filibuster-proof supermajority in the Senate. Obviously, Biden is not going to have that either. And the most recent attempt of this was during FDR when they were trying to block his New Deal. He tried to pack the course, but it turned out to be pretty unpopular, so he gave it up. Right. This is old. This is from my last semester. Remember Merrick Garland, and they denied him his Supreme Court slot. Well, yeah, they didn't do anything about that either. So I think it's highly unlikely. So, all right, I know that was a lot. I'm probably pushing the 20-minute mark now, but this is an incredibly important subject. The Supreme Court, the judicial branch, has a lot of power, but it's not exactly formalized, as we've kind of learned today. And there are also, a lot of issues with it, which mainly stem to the fact that you have these unelected officials that have these term limits that are, picked by presidents that are very partisan, right? Which is something that he's my least favorite Supreme Court justice of all time. Anton Scalia brings up a lot. His writings are absolutely make no sense, but he does make a good point that the Supreme Court, based on the ideals of democracy, doesn't really make much sense, right? So that's it for me right now. There's a lot of questions that you could tackle in this lecture if you want to bring it up in your discussion leader post. I hope you got to, this is just this class is so quick. This is usually a 2 week, lecture, but I needed to give you guys the, very basics about how this branch of government works. So that's it for now, and tomorrow I'm going to get to the civil rights slides, and we're going to mix and mash it all together and hopefully have a better understanding of how all this stuff works. All right, see you next time.